Thank you for tuning into the WOLA podcast. I'm Adam Isaacson. I'm here, as always, to remind you that these podcasts are free. They're ad-free, but WOLA, the Washington Office on Latin America, is an independent organization. We operate entirely on gifts and donations, so please support our independent work. The easiest way to do that is by visiting wola.org, WOLA.org, and clicking on donate. It's right there on the top right of the page. All right. Today, we're talking about the right to seek asylum in the United States. It's a right that's in U.S. law. If you're on U.S. soil and you fear for your life or your freedom due to your race, religion, nationality, membership in a particular social group, or your political opinion, U.S. law since 1980 has granted you the right to at least have a hearing before being sent back to possible danger. To just send you back to danger is a fundamental human rights violation. It's called refoulement. Well, refoulement is happening a lot right now in the United States under the Trump administration. Lives may be being lost as a result. Asylum grant rates have slipped from near 50% to the low single digits in U.S. immigration courts. And it's happening due to a series of layered obstacles that the Trump administration has been putting in the way of asylum seekers, stacking the deck against them. The numbers I just cited don't even include the people who've been forced to give up their cases because they've been thrown in detention or otherwise made miserable enough to desist from their cases. What are some of these obstacles? This episode looks into this with two attorney advocates whose daily work involves trying to protect the right to asylum from the current onslaught. They're Heather Hogan, who is the Policy and Practice Counsel at the American Immigration Lawyers Association, or AILA, here in Washington. Heather spent nearly a decade working as an asylum officer at U.S. Citizenship and Immigration Services, USCIS, before moving to the Department of State during the Biden administration. She's the co-author or author of a series of publications that AILA has been producing about immigration reform, including how to reform the asylum system. Peter Habib is a staff attorney at the Center for Gender and Refugee Studies at the University of California College of Law in San Diego. Peter has done a lot of past legal work at the U.S. Mexico border, but also with Haitian refugees. Heather and Peter both explain not just how the Trump administration is throwing up obstacles to the right to asylum, but also how some of those obstacles, like safe third country agreements, involve other governments in Latin America. Let's listen. Heather Hogan from AILA, it's great to have you on the podcast. Hello.
Good afternoon. It's nice to see you. Thank you for having me.
It's great to have this chance to talk to you. Peter Habib at CGRS in San Francisco. Hello.
Hey, Adam, thanks so much for having us on. This is great.
I want to get into especially this issue of pretermissions, which sounds like a very technical term, but it's pretty shocking. But maybe we should just start with the basics. You're both attorneys and can explain this better than me, but Section 208 of the Immigration and Nationality Act has said since 1980 that somebody who is on U.S. soil, who has arrived in the United States, who fears return to their country, has the right to ask for asylum. But how is that supposed to work? And how has it been working before the Trump administration?
So I used to be an asylum officer, and I worked for the asylum program for a number of years, both in the field and then in DC. So I can talk about that a bit. So there are two paths to request asylum, essentially, like to put it simply. One is the affirmative asylum process, which is where somebody comes into the country and they request asylum with USCIS, so U.S. Citizenship and Immigration Services, which is under the Department of Homeland Security. Then when it essentially like their turn, there's a backlog of a lot of cases, but when it's somebody's turn, they'll go into the asylum office in person. Usually they have an interview and it's with a trained asylum officer. If the person is represented by an attorney, the attorney comes, they're expected to provide their own interpreter if they need an interpreter. But it's described as a non-adversarial interview. And that's really the idea of it. It just is a chance to sit down and speak with a trained officer who will ask about their paper application and all of the documents that they've filed and talk through their case and figure out if they qualify for asylum or not. And then the other route is people who are in removal proceedings in immigration court. They file, it's the same application, but they file it in immigration court, which is under the Executive Office of Immigration Review, which is with Department of Justice. So it's like two different departments entirely. That is a much more adversarial process because then the applicant is in a court setting with a judge and a prosecutor from the government, a DHS prosecutor who is asking them questions while they're testifying. They'll have their own attorney ask them questions about their case, but then the government attorney also will cross-examine them. So it's a more adversarial process in the context of removal proceedings. And people are not guaranteed an attorney as they are for, say, in like a criminal defense context, where somebody is provided an
No right
attorney
to
by the
counsel.
government. People can pay for their own lawyers to represent them, but there is typically no government provided representation for the defensive process. In some states, in some localities, they have these great programs where they can provide government counsel for people in removal proceedings, but it's very like ad hoc. And so there's no big guarantee.
If you are going before an asylum officer, the asylum officer cannot grant asylum, right?
So what they do, actually, for affirmative cases, the asylum officers do grant asylum. And so the person, if they're found eligible, the asylum seeker would be granted by DHS, so through the asylum office. And they never have to go to court unless something changes and they get put in removal proceedings. But for the credible fear screenings, those are heard by asylum officers. And that's the context in which asylum officers don't make a final decision, because in those cases, those are often people who have been like apprehended at the border or found inadmissible. They request asylum, express a fear of return to their countries, then they get put in this credible fear process. And in that case, asylum officers just screen their case to see if they may be able to establish eligibility in court. And then the asylum seekers will later have a hearing in court about their case.
If for people who arrive at the border, minus people who were subject to Title 42, like during the Biden administration, you had a few million who arrived at the border, many of them turning themselves in to seek asylum. The procedure was usually, well, often they skipped to the credible fear process because there just aren't enough asylum officers, but they were given a notice to appear in immigration proceedings or at ICE and then put into immigration court. So they sort of skipped that process and went straight to the immigration process. Is that what normally happened?
Yes. So if people came to the border, then exactly. So either they might come to a port of entry, and upon inspection by CBP, they would express a fear of return to their country and then be put into the credible fear process. And it's the same for somebody who had maybe entered the U.S. and was encountered by Border Patrol or turned themselves into Border Patrol. Right. They can also express a fear to Border Patrol, and then they would be put in credible fear proceedings. So that's how it used to work in the past.
Right. And I guess work is in quotes, because you had, especially during the Biden years, you had easily more than 100,000 people per month turning themselves into Border Patrol, usually between ports of entry, until the CBP-1 program got started up, which created enormous backlogs in the system. We should also let people know, I mean, when we're talking about asylum officers and immigration judges, both of whom we should also point out are in the executive branch. This is not like a separate, judiciary. They're all ultimately in the chain of command for the attorney general or the president. But how many people are we talking about? I believe there were at least getting close to 700 immigration judges by the end of the Biden administration. I actually have no idea how many asylum officers there were, but it wasn't a big core of people, right?
No, you're right. It's not a huge core. I think at the end of the Biden administration, I would say roughly, because I left asylum in 2021 and went to state, but I think there were roughly 1,000 asylum officers across the country, and that's spread across. Initially, through a lot of the duration of the asylum program, there were like 8 main asylum offices, but there are kind of different sub-offices that have opened up, mostly in major cities is where they're concentrated.
I remember the legislation that the Biden administration in its last month proposed, the so-called border bill, that was going to cut off some access to asylum, also proposed hiring something in the neighborhood of 4,000 asylum officers. So that would have been an enormous addition had that passed. Peter, any comments on the asylum process pre-Trump, particularly the backlogs, or how this was just simply, was this working the way it should?
Yeah, I mean, no. I think just picking up on a few things that you both said, the fundamental point of asylum, right? It's a form of protection, just 30,000 feet here, granted to folks who have fled their home country due to persecution or well-founded fear of persecution based on these really specific protected grounds: race, religion, nationality, membership in a particular social group or political opinion. You can apply for it if you're in the United States. And so Congress codified that in the 80s to align with our international treaty obligations. And I think that's key point number one. And the key point number two is what you said, is just investing in making that really happen. And a third point, which I'm sure we'll come to, is just the fact that none of this is independent. It's not an independent judiciary, as you said, right? It's under the executive branch. So it's highly politicized, and that's where we get this racist, xenophobic rhetoric that creates all these problems. So just emphasizing that, yeah, I totally agree. Investment in the system, in immigration judges, and making it an independent judiciary is really key to ensure that that fundamental point could be realized at all for folks. And also, you mentioned Title 42 as well as CBP-1, which was an app, which on some levels, CBP-1 provided some purported access to the system in some ways, but what did it really amount to? It was kind of a glitchy app on a smartphone, not in a lot of languages, that hinged on facial recognition technology that was really problematic, especially for people of color. Didn't work. They changed how it operated. They had a geofence for where in Mexico people could use it, and that changed. Right. And it created this chaos where the reality is, people are fleeing harm. They're stuck now somewhere in Mexico. They're throttled by this geofence, or there's an incentive to get further north in Mexico. The Mexican authorities are combating that. So anyway, you're really sowing chaos, even just in that app. And of course, more recently with the Trump administration, what they did is they just canceled all these people who had actually secured CBP-1 appointments right on January 20th. You had an appointment, sorry, not anymore.
They turn people away.
They turn people away. Just canceled it. Or for folks who are waiting in Mexico trying to comply with the process, they just had the rug pulled out from under them as well.
Peter, I think you made a really good point about the international obligations side of it that I think gets lost a lot in the discussions about the asylum process in the U.S. The United States is signatory to the Refugee Convention and Convention Against Torture. Like, we have these longstanding obligations that other countries have signed on to. And by signing those agreements, we agreed with other countries in the world to provide a place for people to flee to safety. And in addition to the US's obligations to our partners around the world, I think sometimes people also forget that this idea of providing protection to people stemmed from World War II. That was a huge, big, massive shift, I think, in how people thought about the need to open up our doors to people who need a safe place to live. And for a really long time, this was not controversial. And the US actually was a leader in being an example of taking in people who needed a safe place to live through both the asylum and the refugee programs. For a long time, we resettled the highest number of refugees of any other country, including our counterparts in Canada or Australia, who are also doing great work. But for quite a while, we provided an example to the rest of the world. And that's one of the big changes that has happened over the two Trump terms. And of course, under Biden too, this faltering of our adherence to our obligations and showing the rest of the world that maybe this isn't that important. Maybe it's not that big of a deal. And realistically, I think another thing that people lose sight of is just the sheer number of people who are displaced worldwide. It grows every single year. It's grown exponentially.
Yes.
I think when I started with the asylum program in 2012, I think the number was somewhere in the neighborhood of 70 million or so. And this is refugees, internally displaced people, displaced in their own countries. But now UNHCR is estimating that by the end of this year, there will be 136 million displaced people. So when we think about, I know it seems overwhelming when people hear the numbers of people coming to the border to seek asylum during the Biden term. I know there are I understand people are concerned about the numbers, but when we look at the number of people we grant every year, which is with affirmative and immigration court combined, it's somewhere around, I don't want to misstate it, but 100,000 plus.
Yeah, that sounds about right. Similar to what the refugee program used to be on one side.
The refugee ceiling at its highest was 125,000 people per year. But when we're talking about 136 million displaced people, that is such a tiny drop in the bucket of people who need protection. So I think it's really important to keep in mind both our obligations internationally and to our own laws, and then also like just being sort of like a good example and good citizens of the world and taking in this relatively small number of people in comparison.
Yeah, no, I totally agree. And if I could just emphasize a couple things that you said, Heather. I mean, another way it's a drop in the bucket is that we are the most well-resourced, powerful entity in the history of humanity.
Yeah.
Right. I mean, talk about a drop in the bucket. We're not anywhere near meeting what we could do. We're not doing that at all. And yeah, with that massive power and influence comes influence, which is exactly what you said. Like, yeah, historically, other countries look to the United States as a model. So, when we step up and assume our legal obligations and moral commitments, we can inspire other countries to do the exact same thing. That's critical to meeting the issues that we face as far as the number of displaced persons worldwide. And also just to note something that can get lost amid the kind of chaos, especially of our times, is just the way climate-related factors relate to this too,
Right.
and are displacing people also. And so rather than moving to expand protections, finding alternative, safe, predictable, stable pathways to help accommodate people on the move, we're succumbing to this racist, xenophobic, restrictionist rhetoric and receding. We're going the exact opposite, really problematic direction. So yeah, I totally agree.
Yeah.
It seems like where the US and our close ally counterparts go, we tend to follow each other. The US
Yeah.
restricts asylum, so does the UK, so does Australia. Australia does it, we do it. Like, it seems like the nations who have traditionally been leading in providing protection for people, when we go the opposite direction, then the others follow. So it's not a great trajectory.
That's a good way to get it to where we are now. I mean, first of all, yes, the right to asylum did come out, as you mentioned, of the Refugee Act and our commitments that came after World War II, when the world was horrified by stories of people being turned back and often being killed after they were turned back by countries that could have taken them in. So there were these new international standards. The United States, put this in the law 46 years ago. And for most of those 46 years, it feels like, and I'm not a historian of asylum, but it feels like the sense was, oh, well, this is just to help people fleeing the Soviet bloc or people fleeing the worst dictatorships. But ultimately, you had people very much meeting these criteria who are coming from this hemisphere, including in countries that weren't in a formal armed conflict or not in a formal military dictatorship, but a region that, as you said, Heather, I mean, there's that many more displaced people. Latin America, the Caribbean has been no exception to that, where you've got about 8% of the world's population and about a third of the world's homicides, even if there's not a state of war. So people fleeing, and several administrations just not keeping up with this demand for people needing protection. There was not an increase or a significant increase in immigration judges or asylum officers. So you reached a point where your average judge had a backlog of something like 4,000 cases. People's court dates were years in the future. And then the backlog would go all the way to the border when people came. And these images of chaos were capitalized on by the Trump administration and by this new strand within the Republican Party that is now dominant in the Republican Party, talking about chaos and border crises and open borders and all that stuff. I opened up Twitter to look at some of Stephen Miller's recent tweets. Stephen Miller: the Refugee Act of 1980 has been one of the gravest historical calamities. It flooded America with, he puts in quotes the word refugees from the world's failed societies. There are no, in quotes, asylum seeker on the southern border. They're basically saying that it's most of the people coming to the border are somehow scammers. Again, we could easily reject that because we do know that the grant rates are significant for these people. This is not a needle in a haystack situation. But that's the view of the political group that won the 2024 elections and has been now implementing a whole spate of policies to limit access to asylum. And maybe we should just describe for people what some of these policies have been before we zoom in on the preterm missions specifically. It does feel like they put layer upon layer of barriers to access to being protected here in the United States. Starting probably with the January 20th, 2025 proclamation suspending the right to asylum at the U.S. Mexico border, which remains in place right now. But what are some of the things that listeners should know about how much harder it is to access the asylum system today compared to, say, 2 years ago?
I'll just touch on a few things. I mean, first and foremost on those claims, there is no evidence of widespread asylum fraud at all. This rhetoric is only intended to sow harm, and the requirements are already so narrow, not to mention all the roadblocks, this seriously arduous, dangerous journey that's entailed for anyone attempting to request asylum. Nobody leaves everything they know behind and endures all this hardship unless they see asylum as their last best hope to find safety and security for themselves and their family. But yeah, you mentioned the asylum shutdown policy. Obviously has nothing to do with the legitimacy of someone's claim at all. It's just a
Right.
sort of categorical. Courthouse arrests are a good example of weaponizing federal enforcement against people who are really abiding by the very processes that they were prescribed. They're showing up at their court date.
That means people who were, not detained, showing up to the court date
Right.
as required and being detained at the courthouse by ICE.
It's a total bait and switch. That's a betrayal. Another thing to highlight too is just the way the Board of Immigration Appeals, which is the appellate body, also under the executive branch, supposedly they're supposed to be there to catch errors, right, from the immigration judge, whether egregious or things just happen. And both parties are able to appeal to the board, but it's really been weaponized against immigrants. It's another good example of why immigration judges and the board really need to be independent.
My understanding is that most of the appeals board judges, the BIA judges, were fired and replaced. Is that true?
Yes.
They kind of stack the court.
It's stacked, and they've really kind of gone into overdrive too. I think they've issued, Heather, correct me if I'm wrong, I believe they've issued the highest number of precedential decisions in their history, or at least since 2009. Yeah, so these are decisions that immigration judges are then supposed to follow, right? So it's another weapon really used to advance the Trump administration's mass deportation agenda, where they've published a body of precedential decisions. It significantly narrows the process and relief from deportation that immigrants might otherwise have. And this is just ramped up since the beginning of Trump's second term. And
Can I just ask for an example
please?
from Latin America? In Central America, many people have fled gangs that have territorial control throughout the country. And often, almost every case, either the state is colluding with those gangs or is unable to protect people from those gangs. Hasn't a BIA decision or some other policy decision basically said that people fleeing gangs no longer qualify?
Yeah, they've taken aim particularly at one of the grounds for asylum, which is the particular social group ground. That can really encompass many common asylum claims. So that includes women escaping gender-based persecution, children fleeing abuse and exploitation, families targeted by cartels, right, gang violence, LGBTQ plus folks who are fleeing persecution based on their identity. So yeah, these board precedents that were handed down by the Justice Department make it far more difficult for people to qualify, or for people who could qualify rather to prevail in court. And of course, this is already really difficult for attorneys representing folks to overcome these things, this changing landscape, but it's amplified more so for pro se folks, so people without representations.
That's a really good point about the particular social group cases, because it seems like both in the first iteration of the Trump administration, they were very much targeting grounds that often apply to Latin American cases. And then in the second term, they've just dug in deeper, right? So it did seem to me, being I worked at the Asylum headquarters during the first time around, and there would just be these continuous efforts coming from above us to limit how Latin American applicants could qualify. So because the other grounds, which Peter described a bit ago, are, aside from the particular social group, are race, religion, political opinion. For cases from Latin America, they are different from some of the other parts of the world in that the religion, for example, is not.
Yeah, you don't
course
have
it's not-
sectarianism. Yeah.
Yeah, exactly. Like there is a bit more uniformity in religion, in religious practice, than in some parts of the world. And at least in my view, people are able to practice their religions pretty freely. Like certainly there's some, there are issues with religion everywhere, but it's just not as common of a ground as it might be from some other parts of the world. And race as well. We do see some cases with indigenous applicants, but the countries have their own kind of unique characteristics that lend to the particular social group being more of a ground, more common ground for Latin American cases with the gang violence and the cartel violence, because they don't often neatly fit into one of the others. Like political opinion doesn't often work. People certainly tried political opinion, against the gangs or the cartels, but it doesn't often work. And so in the first Trump term, that was something they immediately went after, was having the attorney general refer this case to himself and then declare that gangs and domestic violence, which is another huge problem. There are a lot of cases in which women were fleeing domestic violence and they could not get protection from the authorities. And so they would come to the U.S. looking for that protection. And then our government said that domestic violence doesn't qualify. Before that, it had been a pretty long-standing, there was case law that it was an
Sort of a
acceptable
precedent, yes.
particular social group. Absolutely. So it was a common ground that asylum officers could grant or immigration judges could grant. And then that all changed. And it just seemed that it was very much targeting particular population. Because I think, at the same time, the U.S. receives more Latin American asylum seekers than other parts of the world. They look at the numbers, and the government tracks the nationalities of asylum seekers and what are the top nationalities applying. And they went for those top countries that they could easily go after.
We need to sit with that idea that the administration knows that there is a high probability that the person they're sending back is going to be killed or domestically abused or otherwise persecuted. But they found a way to do it anyway because they feel it doesn't fit the categories that they made up. That we need to sit with that. As we talk about other ways that this administration has been blocking access to asylum, I would love to hear you explain it to me too, because as they're building a big network of warehouses to increase detention capacity, a memo from last July states that people who at some point, anytime, cross the border improperly, if I'm interpreting this right, all must 100% be detained. They can't get bond and they have to go straight to detention. They're using that a lot now when people show up for their court dates and ICE check-ins also. Could you please explain to folks, because I know there's been media coverage of this and all the habeas petitions that have come out about it, but for non-specialists, could you explain that? It just sounds so amazing that all of a sudden they're reinterpreting 30-year-old law in a way that could result in millions of people being detained.
You're absolutely right. So the administration expanded who qualifies as an arriving alien, and then thus who qualifies for expedited removal and who is required to be detained and who doesn't qualify for bond proceedings. So in the past, typically if somebody's detained in immigration custody, which is a civil, I think it's important to remember that it's a civil violation. It's not a criminal violation unless the government can prosecute people for unlawful entry, but by and large, and they do, but by and large, when we're talking about immigration detention, we are talking about civil immigration enforcement, and they're being detained in a civil setting. They're in a private prison often. Sometimes these are county or state prisons as well, but often with security contractors who are responsible for their custody and their care. So the idea is to make it as expansive as possible, to not have anybody qualify for bond or as few people as possible. Because in the past, people could typically request a bond hearing and ask to be released on bond. And if they weren't a flight risk or a danger to the community, then they could qualify for a bond and be let out, and then they could go through their immigration proceeding in a non-detained setting. Now we're even seeing with AILA members are reporting more, I don't want to say minor crimes, but crimes that in the past would not have qualified somebody as a danger to public safety. We're seeing a lot more crimes being cited by judges as a danger to public safety, and therefore somebody can't qualify for bond or a flight risk, even with misdemeanor charges and stuff. So it's being expanded in that way as well. I think the administration's taken a really expansive view of it. who has to be
Well, they also
detained.
have incentives to show how many criminal, in quotes, criminal aliens they're picking up. That's the orders from Washington.
Exactly. But of course, we're seeing in the numbers and the statistics that the majority, like way more than a simple majority of the number of people who are being detained have no criminal convictions, and many don't have any criminal charges at all. So yeah, so their idea is if somebody ever entered through the border by whatever mechanism, they can be considered like an arriving alien, no matter how long ago it was.
They could have been here 20 years, but they're still arriving. Mm-hmm.
I mean, we're seeing people who have been in the
Right.
U.S. decade being picked up, and ICE and DHS saying that they're subject to mandatory detention, and people are being detained for longer, and the conditions, as we all know, are quite poor. The numbers of detainees are much higher than they've ever been in the past.
15 deaths so far this calendar year. It's shocking. So that's what's happening. You've got all of these ways that they're blocking access to asylum, but also finding ways to fill, de-documenting people, also taking away parole statuses, for instance, but also filling this network of detention centers with a very scary plan, using warehouses around the country to expand it more. In that context, why don't we talk about one of these ways that involves Latin America quite a bit, particularly right now, Honduras and Ecuador, are these so-called safe third country agreements or asylum cooperation agreements. My understanding is that countries are being pressured to sign agreements to take a certain number of citizens of other countries and let them apply for asylum in their system. There's other agreements that are just sort of like, take some third country people and do whatever you want with them. That seems to be what's happening, for instance, with Mexico, maybe with Guatemala. But I'm aware of Honduras and Ecuador in particular, but there probably are others. Could somebody do a better job than I can of explaining these asylum cooperation agreements?
I can hop in on this one. I mean, yeah, it's maybe just starting broad to pick up a key distinction that you made. There are a few forms these third country agreements can take. With respect to asylum cooperative agreements, so-called asylum cooperative agreements, specifically, the government's entered into agreements with Belize, Ecuador, Guatemala. That one seems like maybe a little bit of a hybrid, or they're doing a bit of both. Honduras, Paraguay, and Uganda. We think probably also Liberia. Putting a pin in that. These other forms versus asylum cooperative agreements, there are these arrangements to incarcerate forcibly transferred folks in third countries. So for example, like with El Salvador, arrangements for temporary transfer before onward return to their country of origin.
That was Costa Rica and Panama last year, right? Okay.
Yep. And then there's also Equatorial Guinea and Cameroon.
Wow.
And then the asylum cooperative agreements, and then maybe these mixed agreements that are a little more ambiguous, like Mexico, as you mentioned. Mm-hmm. But yeah, distinct in that folks are supposed to have some access to some asylum system under these so-called asylum cooperative agreements versus, for example, El Salvador, which is just acting as a punitive jailer for the United States.
You can't just terminate someone's asylum case and send them to Mexico right now.
Right.
But you can do so for, say, Honduras.
Right. Yeah. And basically the impetus behind this, I can just give a quick history, but Section 208A2A is the impetus from the Immigration and Nationality Act. And basically that's what's known as the safe third country provision. So that's to say that U.S. law provides that an asylum seeker can be removed to a, quote, safe third country, so not their home country and not the United States, pursuant to an agreement, which is to say an asylum cooperative agreement with that third country. But it requires that first, the person actually be safe in that country, and second, that they have access to a full and fair asylum procedure there. And critically, just putting a note kind of in advance that the statutory language only references asylum. It doesn't reference related protections like statutory withholding or protection under the Convention Against Torture. Mm-hmm. So it's supposed to only apply to
just asylum.
Supposed to be. So the quick kind of history, I think the context is relevant, is the first Trump administration signed asylum cooperative agreements with Guatemala, El Salvador, and Honduras to enable folks to be removed there.
The only agreement was with Canada, I believe.
Exactly. And yeah, so the Trump administration comes in, signs these new agreements, and issues this interim final rule in 2019 purporting to implement those. That rule does reference withholding and Convention Against Torture protection.
Oh, wow.
In addition to asylum. Right there, immediately there's a problem. It violates the textual limits of the statute, right? It conflicts. With COVID-19, basically those agreements kind of stopped being implemented. The Biden administration came in, terminated those agreements, but left the rule on the book. And so now we have these new agreements that Trump 2.0 is signing, and it's supposed to be pursuant to that 2019 rule. So you came in, let's say you came into the United States, and sometime after 2019, but before 2025, when they signed an agreement with, say, Honduras, the government is arguing that you're subject to that agreement, even though it came into effect after you were here. That's a big due process retroactivity issue there also right away. And just noting, as I continue to ramble here also, that some of these agreements like Honduras do have specific numerical caps. Honduras is 10 folks a month is what they agreed to in agreement.
It's 10.
Yeah, it's just 10 per month. And it also says, and or 240 total over the course of 2 years. So kind of really emphasizing that 10 max per month. Other agreements are a lot sketchier. But again, just regardless of what may be explicitly in the agreement, the issue of capacity and safety is still there. And we're really talking about a number of countries with quite dubious human rights records and very limited asylum systems.
There are a lot of asylum seekers coming from those countries. Putting them back in those countries to seek asylum is pretty notable.
Exactly.
Not even 10 years ago, I don't think, a country like Guatemala, for example, the number of asylum officers they had was, I believe, in the single digits. And I also think that the number of cases they granted was in the single digits. So the capacity, which Peter mentioned, of a lot of places to actually process any significant number of asylum seekers is extremely limited. Yeah. And then regarding the safety question, I looked to see with AILA, we've done this policy brief series about asylum access, immigration courts. In the course of that, we were looking at agreements also. And there was a statement that UNHCR has on their website about Honduras as an example. And it says that Honduras is characterized by a complex context of violence that disproportionately affects women, children, adolescents, and youth, who often find themselves forced to flee their homes in search of protection and humanitarian assistance. So we're talking about sending asylum seekers to request asylum in a place where they already have their own issues with violence and internal displacement. It doesn't really make sense. And even some of the countries that I think are a little more obscure. So I know I looked at the is it Third Country Deportation Watch? Is that what it's Refugees International and Human Rights First has this fantastic website that tracks the agreements. And between official ACAs, some cooperative agreements, and then just other third country agreements, there are quite a few now. And one I noticed as an example with St. Lucia. And in the State Department own human rights report from 2024, which is the last year available, it said significant human rights issues included significant presence of any of the worst forms of child labor, and also that the government did not take credible steps to identify and punish officials who committed human rights abuses. So even for a place that's more obscure, and that I think, at least for Americans, we don't think much about St. Lucia and like human rights abuses. But in most of these countries, they have their own issues with human rights.
Can I just add on the safety thing? I have Inside Crime's 2025 homicide rate roundup on the screen in front of me. The top 3 countries in mainland Latin America for homicide rates. And homicides aren't everything, but they're an indicator of safety. Ecuador is in first place. Honduras is in third place. And St. Lucia, were it on this list, would be actually in second place. So these are pretty violent places.
So it doesn't really make sense. I think we understand that there are a lot of incentives that the U.S. is offering to these countries to agree to take people and offer them protection. Some of them are developing and they could use some assistance. So there are definitely reasons they're agreeing. We also know, and Human Rights First and Refugees International reports on their website, and we've also seen it in public reporting as well, that for people who have been sent to some of these countries, we know that there's been like enforced return to their country of citizenship, which is prohibited under the Convention Against Torture. There have been disappearances. They've been imprisoned in high security prisons for criminals. So these aren't having great outcomes from what we've seen of the cases so far.
Yeah, just emphasizing a couple things that Heather just said that I think are so important. Guatemala and Honduras are a good example, right? If we're sending Hondurans to Guatemala pursuant to the Guatemala Asylum Cooperative Agreement, and they're basically just, we have reports of folks just getting bussed across the border.
To the danger they're fleeing.
Exactly. And notwithstanding the porous border, notwithstanding potential threats that can cross that border anyway.
Or the transnational nature of the gangs that are threatening them in those places too. Yeah.
Exactly. And also just underscoring, even all of that aside, the extent to which a government may not have the capacity to just support the basic needs of folks dropped off there, even otherwise under the, quote, best of circumstances, you're leaving them incredibly vulnerable to those other forms of harm that exist.
Very much.
And I think we haven't had a chance to talk about the other types of like preterm missions that are happening in court, but there are other types in addition to the asylum cooperative agreements or the safe third country
let's
removals.
go there.
Preterm missions, I had heard so little of it before this administration that I had no idea. I really didn't know about it. So an immigration judge shall pretermit and deny asylum if an applicant has not established a prima facie case. So if on its face in the application, the applicant has not established an asylum case, then the judge can deny the case. And one important point about preterm missions is that it's not just a termination of the case or a dismissal. They're both denying the asylum case and also ordering the person removed. So it's a removal order comes along with that. And so that's hugely significant.
So that's it. It just doesn't feel like your application is good enough and they can do this.
Yes. And so there are a couple of decisions, and one of them, there's a BIA decision, which is matter of HAAV. And that's a case that I think judges have been relying on to say, like, if essentially on the application, there's this whole like prima facie, they didn't establish a case, then they're just denying the claim. So, but what AILA member attorneys have reported is it can be really minuscule things on the application that the judge is pointing to and saying that they didn't establish a case and then just dismissing it without the applicant getting a chance to testify, even something. So the asylum application is also very complex. It's long. I think it's like 13 pages. I can't remember. I don't want to misstate it, but it's more than 10 pages. The questions are multi-part. So many of the questions on this multiple page document have their own like subparts. And so some judges have pointed to a subpart not having enough information. As an example, one we've heard quite a bit about is there's a question about did you travel through any other countries on your way to the U.S.? And if so, you can describe what your status was there. If you had status, how long you were there. For people who took a like lengthy, complicated journey to the U.S., that's a lot of information. So what we are hearing is...
So if you took the Darien Gap, say from Ecuador, and you went through 8 countries, you had to have a subpart for describing each of the 8 countries?
Yes, exactly. You have to state the name of each country you went through, what status you had there. If you had no status, you've got to say that. How long you were there, like where you lived while you were there. So it's very complex. This is one question. And it just goes to eligibility, but it doesn't go to like the persecution, typically. It goes to like whether you had status in another country and if you're eligible in the U.S. So they've said, well, you in Ecuador, you didn't list your status in Ecuador or how long you were there. So you didn't sufficiently fill out this application and therefore your case is pre-terminated. So there are a couple of different routes to get to this dismissal of an asylum claim in court where the asylum seeker does not get a chance to present their case. And it's hugely problematic because asylum applications are, as I mentioned, they're long and complex, and the law on it, as we all know, is very complicated. There are multiple grounds a person could qualify for. And for many, many people, they are filling this out on their own. They don't have a lawyer to help them. So it's a really daunting task. And I think it's definitely a serious, serious problem when looking at due process and whether people have a fair day in court to present their case when the case is just being dismissed out of hand. And additionally, a lot of attorneys have reported that the government attorney, when they move to dismiss, they move for a pretermission. They'll do it like the morning of their hearing or a couple days before. And sometimes it's in writing, sometimes it's oral. The one big problem is then that the asylum seeker doesn't have a sufficient chance to respond. So what's then happening is attorneys are requesting continuances so that they can have a chance to respond. If it's one of the ACA or like safe third country pretermissions, that can be very complicated because in those cases, we've heard about judges finding like multiple possible countries they could be sent to. And then the attorney or a pro se asylum seeker is left to express a fear of return to each of those countries and to explain why they think they shouldn't be sent there.
I mean, you mentioned that the incomplete, even minor details on a form can be grounds for one of these pretermissions. But the existence of an ACA and existence of one of these asylum cooperative agreements in another country is also grounds perhaps for pre-terminating or just terminating one of these cases. Yeah,
absolutely. And so until recently, it was one of the main ways that pre-termission was being effectuated. But just recently, there are, I think, some different reasons that people are speculating this happened. But our understanding is that the courts have been instructed not to grant, and I think the government attorneys have been told not to move for pretermissions based on asylum cooperative agreements. We think that that's because they've far exceeded the cap. It's probably, based on the numbers. I mean, it's years.
If you can only do a few dozen people a month.
Yeah, to Honduras, which exactly in Ecuador, some of the primary states that people are being ordered removed to. So they've been told not to pursue pretermissions based on the ACAs, but it's not retroactive. So people whose cases were already dismissed or were terminated and ordered removed to an ACA country or other safe third country, the government is not going back and changing that or giving them another chance.
And you got potentially thousands of people between like November and whenever this stopped, and it could always start again, but thousands of people who the judge said, no, you're going to have to go to Ecuador. Ecuador doesn't have any room. So what happens? Are you stuck in the detention system? Is there a danger to be sent back to your own country because you don't have a case anymore? And even though that's the place you fled because of threats?
Absolutely.
Yeah.
So yes,
Yikes.
people currently detained would be faced with either a protracted period in detention and having to probably most likely have their attorney or find an attorney to do a habeas corpus petition to request of asylum seekers needing to go the habeas corpus route. There have been thousands of them over the last couple of months.
It's incredible.
So either habeas or a lot of people just give up, which I think that's part of the idea too, is to keep people in detention for a very long time. The conditions are terrible and to pressure them to give up and leave and go back to their countries where they could be persecuted. So that's happening too. People are giving up and they're requesting through their attorneys, at least AILA, is an organization of immigration attorneys. The attorneys report to us that clients are then requesting voluntary departure, which is like another legal mechanism to be removed to your home country, aside from a removal order. And then for non-detained cases, who if they've had their asylum case pre-terminated and ordered removed to either their country or another country, they're at risk of being detained at any time. Anything at all. And their work permits are going to run out if they had one, and then they can lose their jobs. We're hearing about that too, with people losing their jobs because of work permit issues, which is also intentional, unfortunately, going after the asylum work permits as another way to disincentivize people from applying.
Yeah. And I just want to pick up on a couple things also. Again, the data is imperfect, but indications are that at least 11,000 of these ACA-based motions to pretermit have been granted, right? So orders of removal between November and January. So it's a huge number of people.
And those
So
were
yeah,
doing
this
them before
fiction
that
that
too.
those few countries are going to be able to take 11,000 people and put them in their asylum
Yeah.
system at some
Yeah,
point.
that's the
Wow.
fiction. And in addition to folks feeling pressure to voluntarily depart while in detention, I think, the threat by way of these ACAs is there before that also, right? Like the threat of being sent to Uganda, you've never been there, you have no contacts, nothing.
Sure.
You might just want to drop your case right before you're
Right.
necessarily even in detention. So there's that too. And as Heather said, we don't know exactly why they paused this or what it is. I'm maybe a little skeptical that anyone was sincerely concerned that these other countries might not actually be able to take all these people, because I do think, if nothing else, it
Sure.
is fueling, people giving up on their claims or otherwise putting them in detention. And as you mentioned at the top, we're expanding this sort of Kafkaesque system of warehouses to house human beings. And just one other note, as far as DHS's attempts to pre-dermit cases, there are also a lot of reports of these kind of combination motions, right? So there are 3 relevant Board of Immigration Appeals cases here, and Heather spoke about them all really, but one of them is CARR, the other one is HAAV, and then the last one has to do with the ACA-based pre-dermissions, which is CIGM. CARR is the one, if you haven't provided substantive specific answers to everything on the asylum application, then the immigration judge can pre-dermit the case, which, underscoring the absurdity that Heather already spoke about, the process is supposed to be in the court, not on that piece of paper, not on the application, right? This is supposed to just be I filed it, a means of entering the process. HAAV is the one that is, as Heather said, the prima facie eligibility, and CIGM is the one that basically says you can be removed under these asylum cooperative agreements. We've also seen judges order folks removed sua sponte, so of their own accord. The government attorney doesn't even file a motion. They just say, hey, you know what? You're subject to this because you're not from this place and we have an agreement. But then there are these combination motions where the government will file a motion to pre-dermit and say, we think you haven't established prima facie eligibility, or in the alternative, you're subject to the Ecuador ACA or the Honduras ACA or the Guatemala ACA or Uganda. We've seen all of them in one. So if the judge gives you, if you're represented for one, and the judge gives you time to respond, come up with an opposition, right? Because at the beginning of this, again, as Heather also mentioned, but particularly at the beginning, all reports that we received were that these were being filed orally, right? No notice, just show up in court and here it is. But even up until the pause, which happened last month, it was still just very, very little notice. Again, as Heather said, within a couple hours or a couple days, whatever the case may be. But if the judge gives you time to respond, which isn't always necessarily going to be the case, you have to respond to all of that. And so just, emphasizing again, very, very difficult thing to do, and a lot of pressure on asylum seekers at that point to say, I've never been to any of these places, and overcome that.
So as a result of this, we haven't even mentioned all of the policies that this administration has used to deny access to asylum, but as a result of this, we're seeing approval rates, grant rates, asylum in immigration courts, which reached 50% or more in immigration courts during the Biden years, now in the low single digits. There are just too many hurdles to try to climb over and too many disincentives like the long time detention to keep this happening. There is a term that maybe a lot of our listeners are familiar with called refoulement. It is a basic, terrible word, but it's a basic human rights violation, sending someone back to a place where there is a high probability that they are going to be, killed or imprisoned or otherwise gravely harmed. And it looks like a lot of refoulement is happening right now and getting worse. Now, I guess maybe just a big picture concluding question. I mean, what is being done now, and perhaps in the cases of pre-termissions, but in general, to try to stop refoulement from happening to the extent possible? And if you're willing to talk about it, I don't think anybody remembers the Biden years as a golden age for the right to seek asylum in the United States. The problems go deeper and the reforms that are needed are much larger. This is a topic for a whole other series of podcasts, much less like the concluding remarks in one podcast. But any thoughts about just general principles that we have to be following and rescuing here?
I can give a plug for AILA's the policy brief series that we did.
These are
recently
great.
because-
Yeah.
Thank you. Greg Chen and I worked on one specific to asylum and looking at past practices, current, what's going on right now, and then possible solutions. So first, I think immediately the people need to have access at the border to request asylum. And we think that there could be some creative solutions to make the asylum system work more efficiently and also have it meet its humanitarian aims. One thought is to have all of the asylum cases go to asylum officers, to the asylum division under USCIS, instead of the cases that go to court first. Have asylum offices adjudicate all of those first. Because when in the asylum offices, it's, as I mentioned, a non-adversarial proceeding. I know it's still very stressful for asylum seekers, but it's less stress than being in court, just sitting down with somebody. It takes the pressure off of the immigration courts because a huge number of the cases in the backlog on their docket are now asylum cases. When an asylum officer finds somebody is not eligible for asylum, they refer them to court anyway, so that they then get a hearing in front of a judge. So cases found not eligible go to the court eventually, but we think it would be better to just have all of the cases go to the asylum offices first.
So we need a hiring spree of asylum officers.
Those 4,000 officers could have some work to do.
Mm-hmm.
So that's really important. And then also something Peter alluded to earlier, but providing more pathways to get asylum or refugee status in the U.S. There have been attempts at different programs in the past there was a Central American minors program, for example, where cases were adjudicated in the country of citizenship of the asylum seekers, which have more pathways so that people can seek asylum or refugee status without having to undertake this really, really risky journey to the U.S. I think there are a lot of different avenues that can be quite creative. And yes, expanding the refugee program, because that's been severely curtailed, have the refugee program back up to speed. So the cap right now is I think it's 7,500 for this year when it's been around 100,000 plus, for quite some time. Those are some avenues, I think, to get the programs going again and make them more humanitarian oriented than they are right now. Also, AILA has long advocated for providing representation in court to indigent asylum seekers and to other people seeking status. That would help as well. It's much fairer and it's actually a lot more efficient. Because
the grant rates are so different too when someone has an attorney able to explain.
Yes, absolutely. So there's, I think, just a few ways that we could try to tackle the issues.
That's a good start. Thank you.
I mean, I think first and foremost, I don't think people want a system where we spend billions of dollars terrorizing immigrant communities, jailing parents and kids, shipping refugees off to countries where their lives are in danger, right? Violating the obligation of non-refoulement, as you said. They want to see investments in communities that help everyone. Since sustained investment in building a better system, though, there's been this tension for a long time. But political leaders of both parties, including Biden, have just really spent decades spending billions in failed policies that punish people just trying to seek safety in hopes that they're going to make the process so onerous and unbearable. This is just the zenith of it at the moment, but just so unbearable that it's going to prevent people from coming at all. The supposed deterrent, which again, in context at the top, we're talking about, what drives someone to undergo this. I just keep using the word arduous, but
you've walked with a kid through the Darien Gap. What's going to deter you?
What are you going to do? Yeah. We hope that the Biden years would usher in something a little different, an era where people could actually be welcomed with some degree of fairness, dignity. And he promised that, of course, but instead, we saw that they adopted many of the cruel policies that Trump 1.0 had in place, and that had nothing to do with whether or not they worked or whether it was something that anybody anywhere ever wanted. It's just, to me, it's just political cowardice. This is the latest and worst iteration of that. This shutdown policy at the border and mass detention and deportation agendas are just about inflicting cruelty So,
Yeah.
I think bottom line is just our asylum system just needs to center first and foremost human rights and due process, right? Deliver timely and just decisions and adhere to established U.S. obligations, right? Under U.S. law and international obligations. Comport with those.
Start with basic international standards that have been tried to be in place since the end of World War II. We could talk about so many more things, like getting the immigration system out of the executive branch. We could talk about why it makes sense for people to have to walk all the way to the U.S. Mexico border to begin with when they need protection. But no, it's such a huge discussion, and we have covered a lot of important ground here. And I hope that we've given a lot of new information to people who are listening to this podcast. Not all of them are migration specialists, but really need to know what is being done here in the United States and often involving countries in Latin America. Peter Habib and Heather Hogan, thank you so much for your time and your remarkable clarity. I always have some trepidation with attorneys. Are they going to hit me with so much like legal jargon that I'll feel like I'm flunking law school? But you guys were great. You were super clear. And I think our listeners are really going to get a lot out of this. So thank you again. Have a good rest of your day.
Thank you
Thanks
so
so
much.
much, Adam.
That's
Thank you.
great.
Thank you, Heather, also. Yeah, it was.
And you too.
Thanks.
Thank you again for listening to this, I thought, very good episode. And many thanks to Heather Hogan and Peter Habib for walking us through the current attack on asylum in the United States, how it's playing out, and why this matters so urgently. I see Heather and Peter often in coalition meetings, usually just on the Zoom screen. And it was great to actually have a chance to talk to them more in depth. Their work on defending immigrants is adjacent to what we do at WOLA, working on migrants' rights along the migration route and at the border. But it's a deeply complex specialization, and they did a brilliant job explaining it. I'm very glad they were able to join the podcast. It would be good to have them back, perhaps to raise the profile on solutions once we're in a better political position to talk about solutions and alternatives. Please do stay tuned. We will keep the podcast episodes coming as we have been all year. As I mentioned at the beginning, as with all that WOLA does and produces, we depend on donations and gifts to make these episodes happen. So if you're a supporter, thank you for making this work possible. If you're not, just remember that you could be very easily. We would really appreciate your generosity. But either way, thank you so much for listening. Stay well and goodbye for now.